we love Wednesdays? Yes, we love Wednesdays. Why do we love Wednesdays?
I'm saying this just so we can keep things moving because it's civil procedure day.
That is Civil Procedure Day, that's right. That's why we love it. And today, oh, I have so much in store for you guys. You're gonna love it. Today, I'm gonna continue in my mission to make you the hero clerk for your law firm that you work for over the summer by talking extensively about summary judgment motions and responses thereto. But first, what is happening in your legal universe? Well, I thought that some of you might derive some joy out of someone winning a lawsuit against the LSAT.
Yeah.
So, everybody remember the LSAT? Did you all take that?
Never heard of it.
Did you enjoy it?
A law student gets a major victory before even getting a chance to practice law. It's a landmark case that will now change how students everywhere are going to be evaluated. Mara McDonald live downtown tonight with a historic ruling, Mara.
It is, Devin, and it's a case that's been fought out in federal court for years. Take a look. This is a practice test for the LSAT as part of the logic portion of the test. You see these gaps here? That's for drawing diagrams. Kind of hard to do if you're blind.
Because I can't see the draw.
And the response for the last 8 years from everybody, from the Bar Association to the test maker, was tough luck for you. So he sued, and he won.
You know, what was amazing about this case, and what maybe took it a little while longer to settle, is Angela insisted that a settlement in this case wouldn't just be for him, that it would literally apply to everybody in the United States.
The makers of the LSAT have 48 months to change the test. No more drawing pictures, which went like this.
A, B, C, D, and E go into a bar, and E is next to A, and A is next to B, and C must be 2 spaces over from E. Where is D? I've never had to answer a question like that in any state or federal court, but that's how we're deciding who's going to go to law school.
After all the court fights and test changes, it will likely be 10 years for Bino. You need to take the LSAT.
Yes. And I will pass.
Jason Turkish, his attorney, who has a long history of civil rights victories, is also severely sight impaired.
I know I'm a better lawyer because of my vision, because it gives me a perspective. Because when I go to federal court, I understand the challenges that my clients face. I know how difficult it is. I know that it's hard to want to achieve something and be held back solely because of your vision.
Back here live, an interesting footnote to all of this. Turkish is the second attorney to handle this case. The first, Michigan's blind Supreme Court Justice, Richard Bernstein, who had to give the case up once he went to the Supreme Court bench. We're live downtown tonight. I'm Mara McDonald, over 4.
All right, so in addition to this being sort of a gratifying victory for those of you who hated the LSAT, I hated the LSAT. Worst test I ever took in my life. The bar exam, nobody knows what you get on it, right? You know, so I just tell everybody I got 100% on the bar exam. Nobody knows any different. But in addition to the satisfaction of having won a victory over the LSAT, procedurally, what's interesting about this case, do you hear what they said? It's going to take 10 years from the time that they filed the case to when the final result happens. The changes are made in the LSAT that relieve test takers of these horrible diagram logic problems. Okay? How can a civil case like this take 10 years? How does that happen? Well, let's think about, ignore what's on the board for a minute. Let's think about what happens in a civil case, right? You file the complaint, then there's dispositive motions. What are dispositive motions? Motions to dismiss and hearing it. And what else? What else is a dispositive motion? What?
Summary judgment.
Oh, yeah. Motion for summary judgment, good. We're gonna talk a lot more about that today, Friday. And then maybe the plaintiff survives all the dispositive motions, and then what happens? Well, you've already been through discovery by the time you get through summary judgment, probably, right? But yeah, there's a big discovery period. How long does discovery take? Can discovery take 2 years?
And it depends on what side of the case management plan.
Sure it can. Sure it can. Can it take longer than 2 years? Sure it can. Sure. And let's assume you go to trial. You win the trial, and what's going to happen after you win the trial? Probably going to be appealed, right? How long does an appeal take, do you think? Just like I tell my legal writing students, you have very strict deadlines as to when you must turn in your brief. Does the court have a strict deadline as to when it must get its opinion back to you? You're at their mercy. Can it take a year? Sure. Can it take 2 years? Sure. Right? So all those time periods add up. And what if on appeal, the Court of Appeals says, no, something wrong happened below. And we're going to reverse the case and we're going to send it back down, and you have to have another trial. Start back at square one. You've done your discovery and everything. But you got to go through another trial. Can that take another year? Sure. So it piles up. But I got curious about this one. And it turns out this is a bit from the conclusion in the Sixth Circuit on the news story that we just watched, Mr. Bino's case. And what they say here is that the case, which was originally filed in 2011, was actually filed against the wrong defendant. Right? That being the American Bar Association. What Judge Daughtry says here, we are left puzzled by Bino's failure to litigate against the LSAC rather than the APA. For those of you that are far enough along in con law, this is a standing issue. ABA is not the right defendant. They don't administer the LSAC. They don't do that. So about 6 of those 10 years were spent litigating against the wrong entity. How could he then turn around after those 6 years at the trial court, appealing up to the Court of Appeals, then asking the United States Supreme Court to review the case? The United States Supreme Court says no. You fully and finally lost a case against the ABA. How can you then turn around and file against the LSAC? How is that possible? Hasn't he already given up the opportunity or blown a statute of limitations or something? Let's think about that. Why isn't the statute of limitations blown on this? Let's start there. How can he turn around and file another lawsuit against the LSAC?
Well, isn't there kind of like a new claim if you go, so if he wants to take the LSAT again, doesn't that create a new claim?
That's right. It's an ongoing injury. It's an ongoing injury. They're still doing the wrong thing. It's still affecting him. Okay? He still can't take the test because of his disability. So statute of limitations is not the issue. Interesting stuff. If you don't think that you will spend 10 years of your life litigating one case, well, we'll see. All right, summary judgment. summary judgment. The thing that you are going to be doing a lot of if you work for a civil litigation firm. How many of you have already worked on a response to a motion for summary judgment or a motion for summary judgment? Yeah? A bunch of you. Because this is the stuff that we like to foist off on law clerks. So it might be good for you to know what you're doing when you inevitably get this assignment, which you will if you're working in a civil litigation firm. Those of you that are planning to go into criminal practice have already checked out a long time ago. So where are we in this process? We file our complaint. Well, now actually, let's put our defense hat on. You've been served with a complaint. Like, man, I sure would like to get rid of this complaint. File a motion to dismiss. Motion to dismiss is denied. Now we got to do discovery. Okay? Go through discovery. Do all the wonderful things that we've talked about. Depositions, interrogatories, requests for admissions. Get through the end of your discovery period. You're like, now I'm going to try again to get rid of this case. That's what the motion for summary judgment is all about. You got that from your reading, right? We know where we are. We're oriented in time and space. Yes? Questions about where we are? What's the standard here? How do you get summary judgment? Keep your defense hat on for a minute. You really want to get rid of that case. What do you have to show the court? Complete that sentence. You get summary judgment. You get to win your case on summary judgment if what? Yes?
First, you have to show that there's no genuine dispute to any material fact.
No genuine dispute to any material fact. Where did you get that?
From FRC.
Say again?
From Rule 56.
Rule 56, A, the very first little part of that, right? You get summary judgment if there's no genuine dispute of any material fact, no genuine issue of material fact. Okay? Remember that. Make that your mantra. That's important. That's the magic language, the beginning of the magic language for summary judgment. How do you do that? Well, that's a lot of what we're going to talk about. Let's first talk about when you can do it. What is the earliest time in the federal court that you can move for summary judgment?
30 days after the responsible discovery.
That's the earliest time you can move for summary judgment? That's not very early. What's the earliest time you can move for summary judgment in a federal court? Respond to a complaint. Is that so? Don't you have to file a motion to dismiss? Do you have to file a motion to dismiss first? You're telling me that a day after you get served with a complaint, you can just file a motion for summary judgment and try to get rid of it? Who says yes? Who says no? Good. Anytime, right? Anytime after the complaint is filed, you can file a motion for summary judgment. Why would you do that as opposed to filing a motion to dismiss? In some ways, it's helpful to understand what a motion for summary judgment is in terms of what a motion to dismiss is not. If that makes any sense. What are you saying with a motion to dismiss? What does a motion to dismiss do in essence? Elizabeth?
Well, I could be wrong, but I think.
We all could, right?
Well, yeah, but I mean, like, I'm not supposed to say that. But
question first. What are you saying on a motion to dismiss? What are you trying to establish? Kelsey?
There's something wrong with the complaint. There is no jurisdiction or there is no claim in the complaint.
Maybe. Whose facts are you using in a motion to dismiss? Seth? Plaintiff's facts. All right. Plaintiff says in a complaint, here's all the bad stuff that happened. And in a motion to dismiss, remember, think back to a couple of weeks ago, what are we saying on a motion to dismiss? Like, okay, fine. Even if all that stuff happened exactly the way that you say it happened in your complaint, my client still wins. Okay? You're playing exclusively on their turf. My client still wins. How's that different from a summary judgment motion?
Summary judgment facts and product discovery and not intellectual property.
That's right. Did you hear him? Think about it this way. Usually, right? This is the way that happens. You've gone through a whole period of discovery. Interrogatories, you've taken depositions, you've got requests for admissions responses, you've got some documents from the other side, you've got all this stuff that establishes a factual record. There's a record in the case now, right? It's not just playing on the plaintiff's turf. There's a record in the case. And you're saying, well, based on that record, there's no genuine issue of material fact. There's no genuine dispute of material fact. Any disputes that we have are trivial and not worth a jury's time. See the difference between those two things? The motion to dismiss is playing exclusively on the plaintiff's turf. We have to assume things are as the plaintiff says they are. In a motion for summary judgment, you're saying, actually, here are the real facts of the case. And what the real facts of the case show. All the deposition testimony, and these interrogatory responses, and all the wonderful discovery things that we've done. What we've actually found out, Your Honor, is that there's nothing worth taking to a jury here. And we see the fundamental difference between those two things. Does it make sense? Because if it doesn't, we can't keep going. Can we keep going? Can a plaintiff file a motion for summary judgment? Who says yes? Nobody says no, right? Plaintiff can. Who's more likely to file a motion for summary judgment? Plaintiff or defendant? The defendant, we've been talking in terms of a defense motion for summary judgment. We'll continue to talk in terms of a defense motion for summary judgment, but why? Why is the defendant more likely to file a motion for summary judgment? Mark, you've got a clever answer. I mean, billable hours. Billable hours, he said. How cynical. How cynical. Now, what's the reason? Beyond billable hours. Let's think about it. I represent poor Mr. McCoy, who was smashed over the head with a beer bottle. Allegedly, exactly, smashed over the head. No, he's my client. He's been smashed over the head with a beer bottle by Mr. Hatfield. We go through discovery. get through our dispositive motions, and we go to trial. And based on the record that we've developed in discovery, it seems pretty clear that the defendant is liable for smashing my guy over the head with a beer bottle. Who's got the burden of proof at trial? Even if it's crystal clear from discovery that he crashed my guy over the head. I never filed a motion for summary judgment as a plaintiff. Waste of time. I want to go to trial. Who's got the burden of proof at trial? What? That's simple, right? It's not a trick question. Who's got the burden of proof at trial, Seth? The plaintiff. The plaintiff has the burden of proof at trial. And if you read Celotex, right, that matters. Everybody read Celotex, right? You know what I'm talking about. We'll get more into that next week. I keep saying next week. On Friday, we'll get more into it. But in Celotex, Justice Rehnquist is saying the plaintiff still has the burden of going forward with this stuff. The plaintiff still has the burden of proof at trial. So they got to show evidence. They got to show something that suggests they can get something. Now, the defendant does not have the burden of proof on the main issues at trial. And so it makes sense for them to volley it to the plaintiff, to say, look, we don't think you can prove your case at trial. You have to prove your case, because the plaintiff always has the burden of proof at trial. You have to prove it, and we don't think you can. That's what a motion for summary judgment says. Does that make sense? Good? Let's keep going. Now, do you argue issues of fact? You do argue issues of fact in a motion to dismiss, don't you? You argue issues of fact. But you are stuck with the plaintiff's facts. You can argue that the facts set forth by the plaintiff, combined with the applicable law, means that the plaintiff can't win. That's how you argue facts in a motion to dismiss. Let's go back to Rule 12D. Rule 12D does an interesting thing. Rule 12D says, if in a motion to dismiss, you need to pay attention to this if you draft a motion to dismiss. If in your motion to dismiss you go beyond what the plaintiff has set forth in the complaint, if you start arguing facts that don't show up in the complaint, what happens? I'll back that up. You draft a motion to dismiss. You argue facts that are not in the complaint. And then what is the court going to do with that motion to dismiss, Jane?
The motion must be treated for a summary judgment.
They're going to treat that motion like it's a summary judgment motion. Right? That's what 12D does. And hopefully that illustrates the difference between a motion to dismiss and a motion for summary judgment. You step outside of what's in the pleadings. Right? Step outside of that complaint. Start arguing about facts that aren't in the record yet. Right off the bat, the motion to dismiss, the court's going to say, nope, that's a motion for summary judgment. We're going to treat that like it's a motion for summary judgment. If you've got your defense hat on, why might you not want to do that? Why might you not want the court to treat your motion like it's a motion for summary judgment? Yeah.
Is it that later in discovery, facts come up that would have allowed you to file for a motion to summary
which is okay if you're in a jurisdiction that allows you to file multiple summary judgments, right? If your court is okay with you filing summary judgment after summary judgment after summary judgment, which some defendants do, right, then that's okay. But if you're in one of those courts that limits you, and we talked about this before, limits you to only filing one motion for summary judgment, if you're limited by local rule, you might not want to use that right at the very beginning of the litigation. Jessica?
In a motion to dismiss, if that's a motion where you're having to assume that plaintiff's facts are true, then in a motion for summary judgment where it's only based on a factual record that's been established through discovery, it's basically treating like those assumptions are in the factual record. That may not be a
Kind of. We're getting there. Yeah, we're getting there. There's a way to look at that too. Okay, so what if, though, put your plaintiff's hat on. You get hit with a motion to dismiss. Let's not even make it that complicated. What if you get hit right off the bat with a motion for summary judgment? 2 days after you file your complaint. Does this happen? Sure it happens. You get hit with a motion for summary judgment, that's the first procedural device that the defendant uses to say, no, we don't want this case anymore. Make the case go away, Your Honor. Motion for summary judgment. The motion for summary judgment says, not that there's some defect in the pleading, but that there's no genuine issue of material fact. The jury can never possibly decide this. Right? How do you respond? We haven't had time to do discovery. I just filed my complaint. I haven't taken any depositions. I haven't tendered any interrogatories. I don't know anything. About the factual disputes in this case. How do you deal with that? You read Rule 56, so you know. Also, it's on the board.
We look at Rule 56D, if like facts are unavailable at the moment of judgment, and then the court can decide if you were allowed more time for this time.
Everybody get that folder that I linked to you on Blackboard? You're all familiar with Blackboard, right? Go. Okay, in here, can everybody access that stuff, please? I hope. There's a declaration of counsel. What that declaration of counsel says, it may or may not have been filed in a real case, says we can't fully respond to this motion because we haven't done discovery yet. We have to do discovery. Okay. So 56 gives you the opportunity to do that. And 56D gives you the opportunity. All right, we gotta keep going. Questions about any of that stuff so far? Good? Yes?
So, I'm just kind of, Rule 5068 is brought into effect if motion for summary judgment is filed as a response to a complaint.
Anytime a motion for summary judgment is filed.
So even after discovery is done. That-
Anytime a motion, yes. Yeah. And now you're making a strained argument. If you add your declaration and say, oh, actually, we didn't see this argument from the defense coming, and we need to do more discovery. You're going to have a tougher time having a court buy into that at that stage of the litigation than you would if you got hit with a motion for summary judgment early on before the close of discovery. Right? You just realize that we didn't answer this question. What's the latest you can file a motion for summary judgment? Oh, you had something else. Go ahead.
So if the defense brings a motion for summary judgment early, are they admitting to the facts alleged by the plaintiff because there's therefore making no different dispute because everyone agrees on the facts?
That It's something that you can argue. It's something that you can argue. But if a defendant is bringing a motion for summary judgment early on, basically what they're saying is that the plaintiff can't prove their case. And early on, that's likely to be true, because you haven't done any discovery. Right? That's essentially what a defendant is saying. When they bring their early motion for summary judgment, you don't have enough evidence to prove your case. And your response is, well, yeah, I don't have enough evidence to prove my case. We haven't done any discovery yet. Give me a chance to do discovery. And that's what the 56D declaration is all about. Okay? What's the latest you can file a motion for summary judgment?
At any time until 30 days after the close of all discovery.
Anytime until 30 days after the close of all discovery, or
The court says otherwise.
when the court says so. Right. You will have laid out all of those details in the federal court anyway, in that handy-dandy case management plan that we talked about after your 26F conference. Everybody remember that? Right. So think about it this way. Motion to dismiss says, if the facts are the way the plaintiff says they are, the case goes away. Okay? Even if it's exactly the way the plaintiff says. Summary judgment says, if the facts as shown in discovery are not enough to create a genuine issue of material fact, the case goes away. Jessica's question. What if there are different interpretations of the same facts? You've done all this fact finding, you've done your discovery, taken your depositions, you've got documents in front of you, and you say this document means one thing, and the other side says, no, this document means something completely different. Yeah.
Then I don't think you can file a motion for summary judgment because that's that's dispute of material fact.
That's what the argument is. Right? How's the court supposed to evaluate that? Hypothetical I give you here, something that I've recently briefed. Right? The easiest way to understand this, you have one eyewitness, but physical evidence that doesn't corroborate what that eyewitness says. Okay? So one eyewitness who is a defendant, police officer shows up on the scene, shoots the plaintiff, right? Shoots and kills them. Plaintiff's estate files an action against the police officer. Now you have one version of events. Only one. Because there's only one eyewitness. That's the defendant. Does this happen? You bet it happens. Defendant says, he was charging at me with a knife. He was coming right for me. I had no choice but to open fire. Forensic evidence, right? Forensic evidence suggests that plaintiff was shot in the back. So now you have two competing versions of the same set of facts. Two competing versions of the same set of facts. How's a court supposed to look at that? What's a court supposed to do with that? There's two competing versions. Discovery turns up two competing versions of the same set of facts. The defendant moves for summary judgment, saying there's no genuine issue of material fact. There's only one eyewitness here. He says he was being charged out with a knife. Case law clearly says the that you can shoot somebody if they're charging at you with a knife. What's your response as a plaintiff? Go ahead.
I was gonna say, I didn't look at the facts in light of most favorable to the non-moving party.
That's right. That's right. I don't think your reading hits that really hard, but it's really important. I can read my scratch. Court is going to look at the evidence, supposed to look at the evidence, right, on summary judgment, in a light that's the most favorable to the non-moving party, drawing all reasonable inferences in favor of the non-moving party. That's how the court is supposed to look at it. Does that make sense? That's more magic language. That's the good stuff you need to be able to draft motions for summary judgment and respond to them. We like magic language. Okay? Come back to that in a second. What do you think goes into these motions for summary judgment? Pay attention here. You may need this. How do you think you're going to structure one of these? If you were going to outline this for me, just the parts, the components of your motion for summary judgment, what would they be? Start with statement of facts is in there. What else? What are your other sections? How do you build one of these? Huh? What's that?
Would there maybe be a standard of review?
Standard of review. Oh, I'm so glad somebody said that. Standard of review. Remember that from last year? Remember standard of review? No, you just blocked it out of your mind. Wasn't that fun? Standard of review is fun. What else? Other components? Huh? Argument, yeah. What goes in argument? Case law. Connecting case law to facts. You guys remember lawyering skills? Remember that? Long time ago. Long time ago. What else?
You have to have a section that talks about what summary judgment is.
That's going to basically be your standard of review. You'll talk about it throughout, maybe in your argument. But that's essentially what your standard of review is. We'll come back to that. What else?
Certificate of service.
Certificate of service, yeah, okay, good. I like it.
Signature block.
Signature block. Well, you've really been paying attention. What else?
You know, like subparts to your argument, like to organize your argument.
Sure. Yeah.
The relief you're seeking, like specifically, even though.
Yeah, I would say something about that, yeah, in your conclusion or your argument section, for sure. Yeah. Grant summary judgment or don't grant summary judgment.
Order.
Yeah, maybe. Yeah, maybe. Check your local rules. Order. What else? What else might you attach to these? Yeah.
Documents or affidavits that.
Yeah. Documents and affidavits. Maybe you attach some exhibits to this thing because you're a competent practitioner. Right? Maybe you add some stuff to your motion for summary judgment or to your response to motion for summary judgment. Right? do you need to add stuff? Well, the rule tells you that you have to make references to the records if you want to show that there is or is not a genuine dispute of material fact here. You have to rely on that record. You're a lot better off if you put those pieces of the record right in front of the court's face. If you have, we talked about this before, if you have interrogatory responses that you received from the other side, can you just say in the body of your argument, well, we got these interrogatory responses from the other side and here's what they say? Are those responses in the court's record? Probably not. Probably not, right? In most jurisdictions, you're not going to file those interrogatory responses with the court. You've got them, but you need to put them in front of the judge's face. Attach them to your summary judgment motion or your response to motion, okay? There it is. And I've given you a couple examples in that folder too. Just stuff that I pulled off Westlaw. A motion and a response that's been filed in federal court. Pretty simple, pretty straightforward stuff. Not in your jurisdiction, so don't rely on it too heavily. Just so you can see how these things are laid out. Again, check your local rule because your mileage may vary. So, standard of review, remember that. Standard of review, if you did it for your appellate problem, basically says, this is how the appellate court should look at what the trial court did. Remember that? Somewhat traumatized by that? This is how the appellate, because it's confusing, right? Standard of review in an appellate brief says, this is how this court, the Court of Appeals, should look at what the trial court did. How much deference are we going to give the trial court? Standard of review in the trial court says something different. Standard of review in the trial court says what? Tell me in plain English. What's your standard of review? Go ahead. Original jurisdiction. No. Does that have anything to do with jurisdiction?
No go.
How could it be de novo?
That's the only one I remember.
I appreciate your candor. How could it be de novo? Because think about it this way. The Court of Appeals can look at something de novo. Meaning, everything that the trial court did, we're just going to crumple that in a little ball and toss it over our shoulder. We don't care. We're going to look at everything with fresh eyes. That's de novo review. Trial court can't do that. There's no other court to base it on. What's your standard of review going to look like for a motion for summary judgment?
Use of discretion.
Abuse of discretion. Same thing. You guys are stuck in appellate court land. Abuse of discretion is the trial court abused its discretion on a call about evidence or something like that, right? Trial court did something wrong. They were allowed to do a lot, but they went too far. Yeah, Elizabeth. What do you mean by that?
That the complaints
We're getting there. We're getting there. Standard of review is telling the court how they ought to evaluate all the stuff that's in your argument section. Okay? Standard of review is basically going to tell the court, this is how you should look at this case. And in summary judgment standard of review, it's going to be, this is how you look at this case under Rule 56. Okay? It's really that simple. So court, you have to determine whether or not there's a genuine issue of material fact. Yeah, okay. And how do you determine whether or not there's a genuine issue of material fact? You evaluate the evidence in a light most favorable to the non-moving party. All right, let's do it again. We're going to try it again. You're telling the court, in your standard of review, this is how you look at this case. Okay? This is how you look at it under Rule 56. And under Rule 56, you, court, have to determine whether or not there's a genuine issue of material fact. And how do you determine whether or not there's a genuine issue of material fact? You look at the evidence in a light most favorable to the non-moving party. I feel a little better about that. This is a standard of review that was drafted in a plaintiff's motion for summary judgment. Okay? It's a little more unusual, but it's the kind of thing that you run into with your standard. That's all you're telling the court. This is how you evaluate this. This is how you're supposed to evaluate everything that comes after this standard of review section. Now I'm going to convince you that there is no genuine issue of material fact, even if you look at the evidence in the light most favorable to the other side. Got it? Easy, right? Mm-hmm. Can you do it? Sure you can. Sure you can. The argument section is just going to say, the moving party says there's no genuine issue of material fact for a jury to decide. Look at the evidence, Judge. We clearly win. The other side says, no, you don't. No, you don't. There clearly is a genuine issue of material fact here, and I'm going to tell you why. And that's where you're doing all the stuff you learned how to do in first year, connecting the law to the facts and making your case. Huh? We'll come back to this hypo because I want you to get started on the thing that I need you to get started on before we go, okay? And we'll do the hypo on Friday. You are the plaintiff. You get hit with the motion for summary judgment that is currently sitting in your folder on Blackboard. That motion for summary judgment is a terrible motion for summary judgment. It is awful. I had asked my TA to draft the worst motion for summary judgment in history. So it's a sitting duck for you. It's easy, right? You get to respond to it and say, this is the dumbest thing I've ever read. Right? The standard of review is wrong. The argument is totally wrong. Maybe even the statement of fact is wrong. I don't know. Here's how we're going to do this. In this group folder, if you had me last year, you know how kind of how I did it. Although I've not attempted it with a group this big, so we'll see. You have 7 different documents here, okay? I'm going to assign you one of these documents to be in. Okay? When you're in, everybody should be able to get in and edit this all at the same time. You know how this works, right? you shouldn't be able to get in 6 or 7 of you at a time and do these all at once, right? So maybe a situation where you have too many cooks spoiling the broth, but we'll see. 1, 2, 3, 4, 5, 6, 7, group 1. Okay. 1, 2, 3, 5, 6, 7, group 2. 1, 2, 3, 4. 5. What do you want in on this now? Now, Professor Arnold has the ability, he's here because he's going to evaluate your rhythm work. He's got the ability to fail you instantly.
What?
I have nothing to do with it. I can't help it. What group am I on?
Yeah.
1, 2, 3, 4, 5, 6, 8, 7, 7. Group 4, right? All this whole row, okay? It's group 5, right? So this whole row is group 6. That makes it easier. Run out of people. 5, 6. You guys just take a group of 8 for group 7, okay?
Okay, so wait, I know it makes you.
All right, tell me if you can't get into your group for some reason. So here's what I'd like to try to knock out today. Give me a standard of review and a rough outline of how you're going to proceed with this response, okay? You can knock out a standard of review real quick. How? Because you're going to plagiarize.
Yes.
Go in and find a great standard of review that's already been filed in some other briefs someplace else, right? And plop that in there, yes. 7. Yeah. There's 8 of you with your group chat.
So, everybody like that? Who is that?
Ready for registration. Well, it's
You know, and it would be great to have the perfect schedule. Always want. I don't know how you go to dance.
You are the president. Standard of review with citation.
sign of the rest of your response. Call upon your assertiveness, exclamation point. How can you look at real life examples of MSJ responses? I expect to see the following by Friday. Attach me / exhibit. Cites to case law and the record. A halfway coherent argument. We are going to look at the class reveal to the end.
Yeah.
Anyway, but no, I mean, I'm sort of teaching 3 classes this semester.
I think this is the outline from but this is what do you know? What? I was working diligently. Is it? Okay, but the thing about it, I think, is that fine? Because the one that was on the sample was like, from the plane. Where it's alright? Oh, you say this is okay, this is the standard. You could put like, you could say that area, they put wall is not right.
No, the introduction is right here. Like, I have introduction and shit, what is it? Like actually, there's the first thing you put in your brief. I guess I'm not like stop working good. It's like one other person. You're right. You were serious. Like no matter what I say, it's like, you don't know. I'm like, whatever. And arbitration